The file was already open on my desk when Dorothy Hargrove walked through the door. I had been senior medical ethics attorney for the state of Minas Veritas for 3 years, 2 months, and 11 days. I had reviewed 417 custody disputes, guardianship petitions, and parental rights challenges in that time. I had memorized case numbers the way other people memorized birthdays. So when the appointment request came through my assistant, Renata Figueredo, flagged under the name Hargrove Family Trust v. Caldwell, I did not need to pull the file to know what was inside it. I had written the agreement myself, 8 years earlier, under duress, in a hospital waiting room that smelled like disinfectant and defeat, at 7 months pregnant, with my hands shaking so badly I had to press the pen against the paper 3 separate times before the signature held. Dorothy Hargrove did not recognize me when she walked in. That was the first thing I noticed, the blankness on her face, the way her eyes moved across my nameplate and did not stop. Elena Caldwell, J.D., M.S. Bioethics, Senior Attorney, Office of Medical Ethics and Family Jurisdiction. She read those words and they meant nothing to her. She sat down across from my desk, smoothed her blazer with both hands, and smiled the particular smile she had always smiled at me, the one that said she was tolerating the room until someone more important arrived. I let the silence sit for 4 seconds. Then I said her name, and I watched her face change. "Hello, everyone. Before I continue, if you have ever been told you would never amount to anything by someone who was supposed to believe in you, I want you to leave a comment below. Tell me what they said. Tell me where you are now. I read every single one and I want to hear your story. Because what I am about to tell you is not a story about revenge. It is not a story about winning. It is a story about what happens when someone underestimates you so completely, so permanently, that they never even think to look up when you are standing directly above them. To understand why that moment meant what it did, I have to take you back. 8 years back. Further, actually. To understand the document sitting open on my desk that morning, I need to take you back 11 years, to a rented apartment in the Colinas district, to a pregnancy test on a bathroom counter, and to the woman who decided, from the moment she heard the news, that I was an obstacle to be managed. I was 26 years old when I met Marcus Hargrove. I was finishing the 2nd year of a paralegal certificate program at Veracruz Community College, working 32 hours a week at a copy shop on Cal 18, and eating a great deal of instant rice because it was 11 cents per serving and I could buy 12 packets at a time. I was not glamorous. I was not connected. I was, by every visible measure, exactly the kind of woman that Dorothy Hargrove had spent her entire adult life engineering her son away from. She made this clear within approximately 40 minutes of meeting me. We were at a Sunday dinner, Marcus's family home in the Palisade Heights neighborhood, a large colonial with a fountain in the front garden that I later learned cost more than my mother's car. Dorothy had set the table with cloth napkins folded into shapes I did not recognize. There was a seating arrangement. My chair was at the far end, next to Marcus's younger cousin who spent the meal on his phone. Dorothy sat at the head of the table. She looked at me once during the soup course and said, "Marcus tells me you're doing a certificate program. That's very practical for someone in your position." I said thank you. She said, "His ex-girlfriend was finishing her surgical residency at Kellerman Medical Center. She's now chief of her department. Lovely girl." Very true. Marcus said nothing. He reached for the bread basket. I kept my face neutral and ate my soup. That was the first of what I came to think of as Dorothy's calibration speeches. Each one was designed to tell me exactly how far below the waterline she believed I was sitting. Over the next 14 months, through the dating, through the engagement that Marcus proposed without telling his family first, through the pregnancy that followed 6 weeks after that, Dorothy calibrated me at every available opportunity. She told me, at a family gathering in March, that she had spoken to her financial advisor, a man named Gerard Osai at Pinnacle Wealth Partners, and had restructured Marcus's inheritance to ensure that certain assets remained protected in the event of unforeseen circumstances. She said unforeseen circumstances while looking directly at my stomach. She told me, at a baby shower she organized and did not invite my mother to, that she had consulted an estate attorney named Franklin Ruiz at the Ruiz and Castillo firm in downtown Palisade Heights, and that a trust document had been drawn up for the baby. She handed me a card for the firm. I put it in my purse. I did not throw it away. She told me, 4 days after I was admitted to Kalina's General Hospital for preterm labor at 31 weeks. 4 days after I had spent 2 nights on a hospital bed being monitored by a perinatologist and trying not to cry, that the stress of the pregnancy was clearly related to my inability to provide a stable home environment. That was the sentence that changed something in me. Not broke. Changed. I was lying in a hospital bed, with a fetal monitor strapped across my abdomen. My daughter's heartbeat was visible on the screen, a fast, small pulse that I had memorized the rhythm of the way I had memorized my own. Dorothy was standing at the foot of the bed in a cream-colored coat. Marcus was in the hallway on a phone call. The nurse had just left. Dorothy placed a document on my bedside table. She said, "This is simply a formality. It clarifies that in the event the pregnancy presents ongoing risks, and in the event that Marcus and I determine a different care arrangement is in the best interests of the child, you agree not to contest those arrangements." I looked at the document. "I am a paralegal," I said. "I know what a parental rights relinquishment clause looks like." She smiled. She said, "Then you know it's standard." It was not standard. It was 4 pages of very specific, very strategic language that I did not have the energy or the legal standing in that moment to fight. Marcus came back into the room. He said his mother was just trying to protect everyone. He said I was being emotional. He said if I loved our daughter, I would want what was best for her, wouldn't I? I signed it. My hand shook on the 3rd attempt. The pen skidded slightly on the 2nd line of the signature block. I remember the exact texture of the paper, heavy stock, 70-pound bond, the kind that costs more per ream than my weekly grocery budget. The total value of the assets Dorothy's attorney had quietly structured to exclude me, I would later calculate, was approximately $63,000. A college fund account in Marcus's name, a small investment property in the Verona Hills district that Dorothy had transferred from joint title, an insurance policy on the baby with a beneficiary designation that named Marcus's parents as secondary after him, with no provision for me. $63,000. The exact cost of what they had decided I was not entitled to. I left the hospital 4 days later with a healthy daughter, a signed document I had not been given a copy of, and the business card for the Ruiz and Castillo firm still in my purse. That night, after Marcus fell asleep, I sat at the kitchen table and wrote down the name of a program on a piece of paper. Master of Science in Bioethics and Health Law, Santorini University College of Medicine. I had found it 6 months earlier, in the waiting room of a specialist appointment, in a magazine article about careers at the intersection of medicine and the law. I had photographed the page and then talked myself out of it 17 times. I folded the piece of paper. I put it in my wallet. I kept it there for 4 years. Marcus and I separated when our daughter Camille was 11 months old. He did not ask for custody. He did not ask for anything. He moved back to his mother's house in Palisade Heights, resumed the life that had apparently been waiting for him there, and reduced his contact with Camille to a birthday card and a check for $200 at Christmas, which Dorothy signed. I did not contest the separation. I did not fight for the $63,000. I did not hire a family law attorney because I could not afford one, and because I had made a decision that night at the kitchen table that fighting Dorothy Hargrove in the present tense was a losing proposition. I had decided to become someone she could not argue with. This took longer than I expected, and it was harder than I am probably telling it now. The first time I applied to the Bioethics Master's program at Santorini University, I was 28 years old, working as a full-time paralegal at a mid-size firm called Delgado, Santos & Ware, paying $412 a month for a 1-bedroom apartment that Camille and I shared with a second-hand crib and a portable dishwasher I had found on the street. The application required 3 letters of recommendation, a personal statement, a writing sample, and a non-refundable application fee of $95. I got rejected. The letter arrived on a Tuesday. I read it in my car, in the parking structure under the Delgado, Santos & Ware building, during my lunch break. The program had received 640 applications for 22 spots. My writing sample was described as showing promise but lacking the academic grounding the committee required. I sat in the car for 11 minutes. I ate half a sandwich. Then I went back upstairs and started rewriting the sample. I applied again the following year. This time I was rejected from the waitlist, which meant I had moved from the bottom of the pool to the edge of it. I framed this privately as progress because it was. The person who changed the trajectory was a woman named Professor Adiz Nwasu, who taught a continuing education seminar in health law at Kalina's Community Legal Institute that I had enrolled in at a cost of $340, paid in 2 installments. She was 61 years old, Nigerian-born, with a PhD in medical jurisprudence from the University of Edinburgh and opinions about patient autonomy that she delivered with the precision of someone who had testified before legislative committees, which she had. She read my second rejected writing sample, which I had brought to office hours without being invited, and she did not say it was good. She said, "You are writing like someone who is afraid of being told they are wrong. Stop being afraid of that, and write what you actually think the law should do." I rewrote the sample a third time in 10 days. Professor Nwasu wrote my third letter of recommendation. She told me later that she had described me as one of the most precise legal minds she had encountered outside a fully accredited program, which felt like the kindest possible lie, but I accepted it. I was accepted to the Santorini University MS in Bioethics and Health Law on a Tuesday in April, with a partial merit scholarship covering 60% of tuition and a federal loan covering the remainder. I did not tell Marcus. I did not tell Dorothy. I did not tell anyone in the Hargrove family because the Hargrove family had made clear, consistently and in specific language, that my ambitions were decorative at best and delusional at worst. I told Camille. She was 3 years old. She said, "Okay, Mama," and went back to her puzzle. That was enough. The one moment during this period when Dorothy's world and mine briefly collided, not that she knew it, was at a pediatric specialist appointment for Camille, who had developed a recurring ear infection that the general practitioner had recommended a specialist evaluate. The appointment was at Kalina's Children's Medical Group, a practice affiliated with the Santorini University Health System. I sat in the waiting room filling out insurance paperwork, health insurance coverage documentation that required me to list secondary policyholders, and I wrote Marcus's name in the secondary field because he was still technically on Camille's insurance policy through his employer. Dorothy had apparently told Marcus to remove Camille from his plan the month before. He had not told me. The front desk administrator, a young woman named Priya, handled it with more grace than the situation deserved. She helped me contact the health insurance coverage office directly and sort out an emergency bridge arrangement that took 40 minutes and 2 phone calls. Camille got her appointment. The ear infection was addressed. The specialist, Dr. Fortunata Blanco, was thorough and kind and did not charge me for the extra time the insurance sorting had taken. But I sat in that waiting room for those 40 minutes thinking about a 4-page document signed with a shaking hand in a hospital bed, and I thought about the name in my wallet, and I thought, I will not be in this position again. I will not be the person who needs someone else to handle the paperwork. I started the Santorini program 4 months later. The MS in Bioethics and Health Law at Santorini University College of Medicine took 2 years and 8 months to complete, because I was doing it part-time, while working full-time and raising Camille largely alone. I finished my thesis, a 94-page analysis of informed consent failures in reproductive medicine, with a specific focus on documents signed under conditions of medical distress, in November of my 3rd year. My thesis committee described it as publication-ready. I knew exactly what I had been writing about. I did not put that in the acknowledgments. The program director was a man named Dr. Sebastião Lima, who had spent 12 years as a hospital ethics committee chair at Veracruz Regional Medical Center before moving to academia. He was quiet, methodical, and allergic to imprecision in any form. He read my thesis twice before approving it. At my defense, he asked me 9 questions. I answered all 9 without pausing. Afterward, he asked me if I had considered the JD track. I said I had been considering it for 4 years. He said he would make a call to the Hartwell School of Law, which had a dual-degree partnership with Santorini's bioethics program for students who demonstrated exceptional research competency. He made the call that afternoon. 3 weeks later, I had an interview. 6 weeks after that, I had a conditional acceptance to the JD program with a full tuition fellowship based on my thesis work. I want to be precise about what this period cost me, because I think people sometimes hear these stories and assume that the protagonist simply powered through on determination alone, and that is not an accurate accounting. The JD program at Hartwell ran 3 years. I attended evening and weekend sessions. I paid for Camille's aftercare program out of a bank account that had, on one occasion in October of my second year, a balance of $47.16. I missed 2 of her school performances. I fell asleep at my desk so many times that I developed a muscle cramp in my right shoulder that persisted for 11 months and required 3 physical therapy sessions to address, which I billed to my health insurance policy and still paid a $240 copay for. I cried in a bathroom stall at Hartwell exactly once, after a contract law midterm that I was certain I had failed. I got an 88 on that midterm. The person at Hartwell who saw me most clearly was a clinical supervisor named Jonah M. Wangi, a family law attorney who ran the school's medical ethics litigation clinic. He was 44, Kenyan-born, built like someone who had once been a competitive swimmer, and still moved that way. He assigned me to a case in my second year that involved a disputed guardianship claim over a minor whose parents had both signed conflicting care directives. The documents were a mess, overlapping authority, ambiguous language, one signature obtained while the mother was under sedation. Jonah looked at my case memo. He said, "You've read documents like these before. I can tell by the way you annotated them." I said, "I have some personal experience with the subject matter." He said, "Good, use it." I graduated from Hartwell School of Law in May, passed the bar examination on the first attempt in September, and accepted a position as associate attorney in the Medical Ethics and Guardianship Division of the State Legal Office of Minas Veritas in November. The starting salary was $61,000 per year. I remember writing the number in my journal that night because I needed to see it in my own handwriting to believe it was real. Camille was 7 years old. She came with me on a Saturday to see my office. She sat in my chair and spun around twice and said it smelled like a library. I told her that was a good thing. There was one moment, during this entire span of construction, when I nearly told Dorothy what I was doing. Marcus's mother had called to inform me, not ask, inform, that she would be taking Camille for a 2-week visit during the summer, and that she had already arranged activities and did not need my input on the schedule. I was standing in my office at the state legal office with a file in one hand and my phone in the other, and I could see, on my desk, the framed copy of my bar admission certificate with my name in embossed lettering beneath the seal of Minas Veritas. I said, "I'll need to review the proposed schedule and confirm the dates work with Camille's commitments." Dorothy said, "I don't think that's really necessary, Alina." I said, "I'll send you an email." I hung up. I did not tell her where I was calling from. I did not tell her what was on my desk. I did not tell her that the document she had put on my hospital bedside table 8 years earlier was currently in a sealed folder in the bottom drawer of my filing cabinet, that I had reviewed every word of it within 6 months of passing the bar, and that I had found something in it that she did not know was there. She had no idea what I had become. None of them did, and I had every intention of keeping it that way. I was named Senior Medical Ethics Attorney for the state of Minas Veritas in March, 18 months after joining the office. The promotion was not typical at that speed. It happened because the prior senior attorney, a man named Dr. Clifford Park, had retired unexpectedly due to a health matter, and because the division director, a woman named Magistrate Serena Acaffer, had been watching my caseload and my outcomes with what she later described as growing professional interest. Magistrate Acaffer called me into her office on a Wednesday afternoon. She was 63, silver-haired, and had the particular stillness of someone who had spent decades making consequential decisions in small rooms. She put a personnel file on the desk. She said, "I am going to ask you to take on a role that will require you to manage conflicts of interest with a level of discipline that most attorneys find genuinely difficult. You will sometimes review documents that implicate people you know. You will sometimes be the person who decides whether a signature is valid or not." "Can you do that?" I said yes. She said, "I'm not asking whether you're capable, I'm asking whether you can do it without it costing you more than it costs the case." I thought about a hospital bed. I thought about a shaking hand. I thought about $47.16. I said, "Yes." She signed the paperwork that afternoon. The title came with a specific mandate: review and adjudication of contested medical documents in family law proceedings, guardianship petitions, parental rights relinquishments, care directive disputes. I was, in the formal language of the office, the final authority on whether medical documents in contested family cases were procedurally valid, legally enforceable, and ethically obtained. I was the person who decided if signatures held. My colleague and closest professional ally in the office was a woman named Priyanka Saith, JD, a former pediatric medical advocate who had spent 8 years working at the intersection of child welfare law and hospital administration before joining the state office. She knew my case history the way a navigator knows a route, not memorized exactly, but understood well enough to anticipate where the complications would appear. She was the only person in the office, in the state system, in my professional life who knew about the document in the bottom drawer. She had read it once at my invitation and said 4 words. "This won't hold, Alina," I had said. "I know," she had said. "Are you waiting for something?" I had said. "I am waiting for her to use it." On the morning that Dorothy Hargrove's custody petition arrived on my desk, routed through the family court system, and flagged for medical ethics review because of the parental rights document attached to it, the document that Dorothy had apparently retrieved from Franklin Ruiz's office at the Ruiz and Castillo firm 8 years after it was signed, and submitted as evidence in a guardianship action against me for my daughter Camille. I had been senior medical ethics attorney for 3 years, 2 months, and 11 days. Priyanka knocked on my office door at 7:43 in the morning and placed the file on my desk. She looked at my face. She said nothing for a moment. Then she said, "You knew this was coming." I said, "I've been ready for it since October of 2019. She said, "Do you want to recuse?" I looked at the file. I thought about the signature block on page 4 of the original document. I thought about the second line, where the pen had skidded. I thought about the procedural provision in the State Medical Ethics Code, Section 14, Paragraph 7, which specified the exact conditions under which a document signed by a patient during active medical monitoring could be considered to have been obtained under duress, and therefore rendered unenforceable regardless of subsequent ratification. I thought about Magistrate Serena Acaffer asking me whether I could do it without it costing more than it cost the case. I said, "No. I'm not recusing." Priyanka sat down across from me. She opened her notepad. I opened the file. At the top of the petition submitted by Franklin Ruiz on behalf of the Hargrove Family Trust, Dorothy had attached a handwritten note. It said, "I believe you will find everything in order." I had come that close to everything surfacing before it was time, but it wasn't time yet. The appointment was scheduled for Thursday at 9 o'clock. It was currently Monday. I had 72 hours, and I intended to use every one of them. Not to build a case. The case had been built for 3 years. In the quiet hours after Camille went to sleep, in the annotated margins of Section 14. In the consultation I had scheduled with a family law attorney named Delia Marchetti at the Marchetti and Osai practice, who had reviewed the document in a professional capacity 18 months prior, and put her assessment in writing in a sealed letter that was currently sitting in a folder directly beneath Dorothy's petition. I had not been waiting to be ready. I had been waiting for Dorothy Hargrove to walk through my door. I spent those 72 hours the way I had spent the previous 3 years, methodically, quietly, and without announcing to anyone outside my office what I was doing. Monday evening, after Priyanka left for the day, I unlocked the bottom drawer of my filing cabinet. I placed the original custody petition from Franklin Ruiz on my desk, beside 3 other files that I had prepared at intervals over the preceding 36 months. The first was a 22-page analysis I had written of the original parental rights document, annotating every clause against the State Medical Ethics Code and the Minas Veritas Family Jurisdiction Act. The second was the sealed letter from Delia Marchetti at the Marchetti and Osai practice, dated 18 months prior, containing her professional assessment of the document's enforceability. The third was a set of certified medical records from Kalina's General Hospital, Camille's birth records, and my own admission records from the week of the signing, which documented, in clinical language, the exact physiological and pharmacological conditions under which I had been monitored at the time I put pen to paper. Priyanka had helped me obtain the third file through a formal records request submitted through the state office's Medical Records Division. We had done it 18 months ago, rooted as a routine document verification for a hypothetical precedent case study. It was not hypothetical. I sat at my desk until 11:30 that evening and I read every page of everything I had assembled, not because I needed to refresh my memory, but because I needed to be certain there was nothing I had missed. There was not. On Tuesday morning at 8:14, Dorothy Hargrove called my office. She did not know she was calling my office. She called the main intake line of the State Medical Ethics and Family Jurisdiction Division, which is a publicly listed number, and asked to speak with whoever was managing the Hargrove Family Trust custody petition. My assistant, Renata Figueredo, routed the call to my desk with a note that said family member of Hargrove petitioner, seems confident. I answered. I said, "This is the Office of Medical Ethics and Family Jurisdiction. How can I help you?" Dorothy said, "Yes, I'm calling regarding a custody petition filed by our attorney, Franklin Ruiz. I want to confirm that the attached parental rights document has been received and is being reviewed as primary evidence." I said, "All attached documentation is received and under review. Is there anything specific you'd like us to note regarding the filing?" She said, "I simply want to make sure it's clear that the document was signed voluntarily and is entirely enforceable." "Our attorney is very confident about that." I said, "Thank you for the note." "The reviewing attorney will be in contact if there are questions." She said, "Wonderful, and who will be reviewing it?" I said, "That information will be included in the formal correspondence." She thanked me and hung up. I held the phone for a moment after the line went dead. She had called the state office to make sure her document was being taken seriously. She had spoken to the reviewing attorney without knowing it. She had told me her attorney was confident the signature was enforceable, which meant Franklin Ruiz had not spotted the problem on page 4, which meant they were walking into Thursday's appointment with full confidence in a foundation that was not there. None of them knew what I had already decided. I called Delia Marchetti that evening. I told her the petition had been filed and the appointment was Thursday. She said she would clear her morning. I signed the authorization form that allowed her to appear in a professional advisory capacity at the review meeting. I filed the form with the court liaison office at 9:47 that night through the electronic submission portal. There was no going back. Wednesday was the day Priyanka and I went through everything together, in the conference room on the 4th floor with the door closed and the blinds drawn against the afternoon light. She placed her copy of the documents on the table. I placed mine beside it. We worked through the annotated analysis first. Priyanka said, "Walk me through page 4 again." "I want to make sure I can articulate it independently if I'm asked." I said, "The signature block on page 4 contains 2 lines. The first line is the primary signature. The second line is the witness attestation. It confirms that the signatory was of sound judgment and signed without coercion. The person who signed the witness line was Dorothy Hargrove." Priyanka looked up. She said, "She witnessed her own coercive document." Said, "She witnessed a document that her own attorney drafted, in a medical facility where she had accompanied the signatory, under conditions that Section 14, Paragraph 7 of the State Medical Ethics Code explicitly identifies as presumptively coercive. A witness attestation signed by an interested party with a direct financial stake in the outcome of the document is procedurally invalid under state law." Priyanka said, "And Ruiz missed this." I said, "Ruiz drafted the document. He would have known the witness requirement. He may have believed that because Dorothy was not a named party in the original document, she was acting as Marcus's representative. She qualified as a neutral third party." Priyanka said, "But she's the named trustee of the Hargrove Family Trust." I said, "Which makes her a financially interested party in any agreement affecting the beneficiary of that trust, which is Camille." Priyanka said, "So the witness attestation is invalid, which means the enforceability of the entire document," I said, "is void from the point of signing, not voidable, void." She sat back in her chair. She said, "Does Ruiz know you're the reviewing attorney?" I said, "The correspondence from our office is signed by the division. My name is on the letterhead in my capacity as senior attorney, but Ruiz filed his petition 3 weeks ago. He may not have connected the name." Priyanka said, "And Dorothy definitely hasn't." I said, "She called yesterday to confirm the document was enforceable." Priyanka looked at me for a long moment. Then she said, "What about the trust documents, the 63,000? I said, "That's Delia's territory. I've given her everything I have on the asset restructuring. The investment property in Verona Hills, the college fund, the insurance policy." The financial disclosure requirements under the Family Jurisdiction Act require full asset accounting in any contested custody or parental rights proceeding. Dorothy filed for custody. She triggered the disclosure requirement herself. Priyanka said, she walked into it. I said, she ran. That was the moment I understood exactly how much they had underestimated me. On Wednesday afternoon, Marcus called my mobile phone. He said his mother had told him the petition was progressing well and that he should expect a resolution by the end of the week. He said this in the tone of someone who is delivering news they were told to deliver and doesn't entirely understand it. He asked how Camille was doing. I said Camille was well. I said she had a school project due Friday on the water cycle and she was very invested in it. Marcus said that was great. He said he hoped things could be resolved amicably. I said, I hope so too, Marcus. He said, my mother just wants what's best for Camille. I said, I'm sure she does. I did not say anything else. He filled the silence with a few more words about amicability and then said goodbye. I put my phone down and looked at the window for a moment. Camille had a school project due Friday. She was currently at aftercare, and at 6 o'clock I would pick her up, and we would eat dinner together, and she would tell me about the water cycle, and that was what was real. That was what the documents in my filing cabinet were for. Not for me. Not for the version of me who had signed a paper with a shaking hand in a hospital bed. For the version of Camille who deserved to have a mother who had not been legally erased by a trust document that should never have held in the first place. I left the office at 5:30. I picked up Camille. We ate dinner. She told me about evaporation for 22 minutes. That was enough. The next call changed the shape of everything. At 7:48 that evening, Delia Marchetti called to tell me that she had, in the course of preparing her advisory documentation, requested a financial disclosure from the Hargrove Family Trust's registered accountant as a routine procedural step available to advisory counsel in contested custody proceedings. The accountant, a man named Philip Voss at Voss and Associates, had apparently not been informed by Franklin Ruiz that the financial disclosure provision had been triggered by the custody filing because he had responded to Delia's request within 4 hours with a complete asset accounting. Delia said, Elena, the college fund account that Dorothy told you had been established for Camille, the one listed as an asset of the trust. I said, yes, she said. It was liquidated in 2021. The funds were transferred to a personal account in Dorothy's name. The current balance designated for Camille in any trust instrument is 0. I was quiet for 3 seconds. I said, is the transfer documented? Delia said, it's in the accounting. Philip Voss had no reason to hide it. He didn't know it was relevant. I said, it's relevant. I let her believe it. That was exactly the point. Thursday morning arrived the way consequential mornings tend to, without announcement, in ordinary light, with the coffee maker doing its usual thing and Camille eating toast at the kitchen table and asking if she could wear her red sneakers to school. I said yes. I drove her to school. I drove to the office. I put on the blazer I had chosen the night before, a dark blue one that I had bought 2 years earlier for a presentation to the State Medical Ethics Review Board, and I sat at my desk and looked at the nameplate that read Elena Caldwell, J.D., M.S. Bioethics, Senior Attorney, and I thought, I have been ready for this for 3 years. I have been building toward this for 11. Renata knocked at 8:40 and said the conference room was set. She said Delia Marchetti had arrived and was waiting. She said a man named Franklin Ruiz had checked in at the front desk with a woman named Dorothy Hargrove and a second man she did not recognize. I said, give them the good chairs, get them coffee if they want it. Renata blinked. She said, sure. I said, I'll be there at 9. I arrived at 9:02. The conference room on the 3rd floor of the State Medical Ethics Division seats 14 people at the main table and has 4 additional chairs along the wall. When I walked in, Franklin Ruiz was seated to the left, a compact man in his late 50s with a navy suit and an expression of professional confidence. Dorothy was seated beside him in a cream blazer, the same color she had always favored, I noted, and to her right was a man I did not immediately recognize who turned out to be her financial advisor, Gerard Osai from Pinnacle Wealth Partners, the same man she had mentioned restructuring Marcus's inheritance through 12 years earlier. He was there, I assumed, to confirm the trust asset accounting. Delia Marchetti was seated on my right. Priyanka was seated at the far end of the table, in her capacity as case documentation officer. 2 staff attorneys from the division were seated along the wall. The court liaison officer for Minas Veritas family jurisdiction, a man named Terence Boateng, was seated at the corner. Magistrate Serena Akafer had, at my request, agreed to be available by secure video connection if the hearing required a supervisory authority ruling. Dorothy looked at me when I walked in. She looked at my nameplate on the table. She looked at my face. I watched her place it. I watched the sequence happen in her eyes: recognition, confusion, recalibration. She was still recalibrating when I sat down. I said, "Good morning, everyone. I'm Alina Caldwell, Senior Medical Ethics Attorney for the State of Minas Veritas. I'll be presiding over today's document review in the matter of Hargrove Family Trust versus Caldwell." I paused for 1 second. "Dorothy," she said. "Elena." Her voice was entirely level. I will give her that. Franklin Ruiz said, "Ms. Caldwell, I wasn't aware you had a personal connection to this matter." I said, "The petitioner's family has a prior relationship with the respondent, which is standard in parental rights proceedings. I am the respondent in this matter, and I am also the reviewing attorney under the division's jurisdiction. Those are not in conflict in this proceeding. If you have a recusal motion to file, Mr. Ruiz, I'll accept it now." He looked at Dorothy. Dorothy looked at me. She said nothing. Ruiz said, "No motion at this time." I said, "Then let's begin." I opened the file. I said, "The petition filed by the Hargrove Family Trust requests the enforcement of a parental rights relinquishment agreement signed in October 2017 at Kalina's General Hospital. The trust contends that this agreement is valid, voluntary, and enforceable under the Minas Veritas Family Jurisdiction Act, and uses it as the basis for a custody transfer petition regarding the minor child, Camille Caldwell, age 8. I looked up. "Is that an accurate summary of the petition's position, Mr. Ruiz?" He said, "That's correct." I said, "Good." I placed the first document on the table. This is a certified extract from my admission records at Kalina's General Hospital, dated October 14, 2017. The extract is certified by the Hospital Records Division and authenticated under the State Medical Records Verification Protocol. I slid copies to Ruiz, to Dorothy, and to Gerard Osai. It documents that at the time of signing, I was under continuous fetal monitoring for preterm labor. I had received a subcutaneous injection of betamethasone 36 hours prior to stabilize fetal lung development. I had not slept in approximately 51 hours. And I had been told by my attending physician that morning that stress was a factor in my preterm symptoms. Ruiz said, "That doesn't necessarily establish." I said, "I haven't finished, Mr. Ruiz." He stopped. I said, "Section 14, Paragraph 7 of the State Medical Ethics Code specifies that a document requiring legal relinquishment of parental rights, signed by a patient who is currently under active medical monitoring in a hospital or clinical facility, is presumptively coercive unless 3 conditions are met. First, the patient must have had independent legal counsel review the document before signing. Second, a minimum of 48 hours must have elapsed between presentation of the document and signing. Third, the witness attestation must be signed by a party with no financial interest in the outcome of the document. I placed the second document on the table. I said, "This is the original parental rights relinquishment agreement. Page 4, second signature line. The witness attestation is signed by Dorothy Hargrove." I looked at Dorothy. At the time of signing, Dorothy Hargrove was the named trustee of the Hargrove Family Trust, which held assets designated for the benefit of the minor child Camille. She had a direct and documented financial interest in the outcome of this document. I looked at Ruiz. That was the first document. I had 3 more. Dorothy's hands, which had been folded on the table, went still. Franklin Ruiz said, "I would argue that Ms. Hargrove's role as trustee doesn't constitute a direct financial interest in the parental rights question specifically." Delia Marchetti said, from my right, in the even tone of someone who has been waiting for exactly this moment, "Mr. Ruiz, the beneficiary of the trust is the minor child. The parental rights document directly determines the custodial and legal standing of the child's mother, which directly determines the management authority of the trust's assets on behalf of that child. The financial interest is structural, not incidental." She placed her own copy of the trust documents on the table. "I have the trust's instrument here. Would you like me to walk through the beneficiary provisions?" Ruiz looked at the trust documents. He looked at Delia. He said nothing. I said, "Condition 1, independent legal counsel. The record shows I had no legal representation at the time of signing. I was a paralegal student with no current bar admission." The document was presented to me without prior notice and signed the same day. Condition 1, not met. I placed the third document on the table. Condition 2, 48-hour window. The hospital records document that the agreement was presented to me on October 14th at approximately 2 in the afternoon and signed on the same day at approximately 4:15. Elapsed time, approximately 2 hours and 15 minutes. Condition 2, not met. Condition 3, I have already addressed. I placed the fourth document on the table. I said, "This is the written professional assessment prepared by Delia Marchetti, JD, of the Marchetti and Osai practice, dated 18 months ago, reviewing the original document against the three conditions standard of Section 14, Paragraph 7. Her conclusion, stated in writing, signed, and dated, is that the document fails all three conditions and is therefore void under state law." The room was very quiet. Terence Boateng, the court liaison officer, made a note on his pad. One of the staff attorneys along the wall had stopped writing entirely and was simply watching. Dorothy said, "Elena," her voice had changed. Not broken, compressed, the way a voice gets when a person is working very hard to maintain the shape of something. She said, "You could have come to us. You could have talked to us about this years ago." I looked at her. I said, "You put that document on my hospital bedside table while I was in preterm labor. You had your attorney draft it. You had yourself witness it. You kept it for 8 years and then filed a custody petition using it as primary evidence." I paused. At what point in that sequence would a conversation have been productive, Dorothy? She had no answer for that. Franklin Ruiz said, "Ms. Caldwell, I want to note for the record that my client filed this petition in good faith, believing the document to be enforceable." I said, "Noted, Mr. Ruiz. And I want to note for the record that believing a document to be enforceable is not the same as it being enforceable. That is the function of this office." I looked at Terence Boateng. I said, "Mr. Boateng, will you note for the court record that the Parental Rights Relinquishment Agreement attached to the Hargrove Family Trust Custody Petition has been reviewed under Section 14, Paragraph 7 of the State Medical Ethics Code, and found to be void on the grounds of procedural invalidity. Specifically, absence of independent legal counsel, failure to meet the 48-hour presentation window, and the disqualifying conflict of interest in the witness attestation." Boateng said, "Noted and recorded." I said, "The petition is denied. The parental rights of Elena Caldwell with respect to the minor child Camille Caldwell are intact, undisturbed, and not subject to further challenge on the basis of this document or any document derivative of it." Gerard Ose had not said a single word during the entire proceeding. He was looking at a point somewhere above the door. I turned to him. I said, "Mr. Ose, the financial disclosure submitted by Philip Voss at Voss and Associates indicates that the college fund account held in trust for Camille Caldwell, valued at $63,000 and including the Verona Hills investment property equity, was liquidated and transferred to a personal account in Dorothy Hargrove's name in March of 2021. I placed a copy of the Voss accounting on the table in front of him. That transfer occurred after the trust documents designated those assets for the benefit of the minor child. Under the Minas Veritas Family Jurisdiction Act, that constitutes a breach of trustee fiduciary duty. I will be referring the financial disclosure to the State Family Court for review and a formal accounting order." Ose looked at the document. He looked at Dorothy. Dorothy was looking at the table. She took one breath, then another. She put her hands flat on the table, and then, in a voice that was very quiet and very controlled, she said, "I never thought you would become this." I said, "I know." That was all I said. Magistrate Acaffer had been watching via the secure video connection from the beginning of the proceeding. She had not spoken. When I looked at the screen, she gave a single, small nod. I closed the file. The custody petition was formally dismissed by the Minas Veritas Family Court on a Friday morning, 17 days after the conference room meeting. Terence Boateng delivered the court order to my office by messenger. It was 2 pages. It confirmed the dismissal of the petition, the invalidation of the parental rights agreement, and the referral of the Hargrove Family Trust's financial records to the State Family Court Fiduciary Review Panel. Dorothy Hargrove did not contest the dismissal. Franklin Ruiz filed a professional notice with the State Bar, acknowledging that his office had submitted a document for enforcement without fully evaluating its procedural validity. The bar inquiry that followed resulted in a formal letter of admonition on his record, and a mandatory continuing education requirement in medical document law. He retired from practice 14 months later, which I learned from Delia, who mentioned it in passing during a lunch. We had to discuss a different case entirely. Dorothy's trusteeship over the Hargrove Family Trust was reviewed by the fiduciary panel. The panel found that the 2021 liquidation and transfer of the college fund assets constituted a breach of fiduciary duty. She was ordered to return the transferred funds with interest. The order specified a total recovery amount of $71,420, the original $63,000 plus compounded interest over the intervening years. A court order was issued directing the funds into a new, independently administered college savings account in Camille's name, managed by a neutral trustee appointed by the court. I was listed as the authorizing parent on the account. Marcus called me after the court order was issued. He was quiet for a long time. Then he said, "I didn't know about the liquidation." I said, "I know, Marcus." He said, "I'm sorry about all of it." I said, "I know." I meant both answers. There is a version of this story that ends with me savoring every moment of that conference room, replaying Dorothy's silence and Ruiz's faltering, and the look on Gerard Osai's face when I put the Voss accounting in front of him. I would be lying if I said I felt nothing. I felt something. But it was not triumph, not exactly. It was closer to the feeling of setting down a weight you have been carrying for so long that you have forgotten what it felt like before you picked it up. Relief, and underneath the relief, something more complicated. Dorothy Hargrove is 71 years old. She believed with full sincerity that she was protecting her family's interests. She was wrong about the method and wrong about the law and wrong about me, comprehensively, across 11 years. But she is not a cartoon. She is a woman who miscalculated and spent 11 years confident in that miscalculation, and the unraveling of that confidence in a fluorescent-lit conference room, in front of her financial advisor and her attorney, is not something I enjoyed. It was necessary. It was correct. It was not something I enjoyed. Camille does not know the full shape of what happened. She knows that a legal matter was resolved. She knows that there is a college account in her name. She knows that her mother is a lawyer who works for the state and sometimes comes home later than she would like. She is 8 years old and she is building a map of the world, and I am trying very hard to make sure that the map includes the knowledge that institutions can protect people, that documents matter, that being precise and patient is not the same as being defeated. I am still senior medical ethics attorney for the state of Minas Veritas. I am still in the same office, with the same nameplate, with Renata at the front desk, and Priyanka 2 doors down, and Magistrate Akaffer's quiet nod available on a secure connection when the proceedings require it. My caseload is 461 reviews since I took the role. Every one of them involves a document that someone, somewhere, believed was enforceable. Every single one of them gets read. I am 37 years old. I have a daughter who wants to be either a marine biologist or a pastry chef. She is weighing the options seriously, and I have been advised not to rush her. I have a joint on the eastern side of Kalinas that costs more than the instant rice apartment and less than I worried it might. I have the piece of paper that I folded and put in my wallet 11 years ago, framed now, behind my desk, between the bar certificate and a drawing Camille did of the two of us in crayon when she was 4. The Santorini program name is still legible on the paper, in my handwriting in pencil slightly smeared along the fold. I did not throw it away. And if there's anything this experience taught me, it's this. 1. The quietest kind of power is the kind built entirely in private, where no one who doubts you can see the foundation going in, and by the time they arrive to challenge you, it has already been standing for years. 2. A document is only as strong as the process that produced it. Sign something under duress in a hospital bed at 2 in the afternoon and someday, if you do the work, you will be the person in the room who decides whether it holds. 3. What a family decides you are is not a diagnosis. It is an opinion, offered without credentials, and you are under no obligation to accept it as fact. Was I wrong to wait 8 years without telling anyone in the Hargrove family what I was building, to let them believe for almost a decade that I was exactly what they had decided I was? I have thought about that question more than any other. Tell me what you think in the comments. If this story gave you strength, hit that like button. It means more than you know.